Hello friends, welcome to our channel SNK and Company. Let us begin with this week's updates under the Income Tax Act, GST law, and other corporate laws. We start with the Income Tax Act. The Delhi Tribunal in the case of Little Pearl Charitable Society versus Principal Commissioner of Income Tax held that where the Principal Commissioner had canceled registration granted under Sections 12A, 12AA, and 12AB retrospectively from assessment year 2013 to 14 by invoking Section 12AB4. Such retrospective cancellation was without jurisdiction. The tribunal observed that the expression specified violation was introduced by the Finance Act, 2022 with effect from April 1, 2022, and was applicable only from assessment year 2023 to 24 onwards. Therefore, cancellation of registration for earlier years on that basis was liable to be quashed. The Mumbai Tribunal in the case of Shri Tandon Saldana versus Deputy Commissioner of Income Tax dealt with valuation under Section 5622X. The assessee had booked a residential flat in 2011 and paid the entire consideration through banking channels prior to allotment. The agreement for sale executed in 2017 merely recorded earlier payments without altering the agreed terms. The tribunal held that the allotment letter constituted an agreement to sell for purposes of Section 5622(xb), and therefore stamp duty value as on the date of the allotment letter was required to be adopted. Accordingly, the addition made by adopting stamp duty valuation as on the registration date was deleted. In the case of Asit versus Bir Kumar Jain, the Delhi Tribunal considered the validity of assessment following a search. Jewelry in the assessee's name was seized during a search conducted at the residence of the assessee's son. The last panchnama was drawn on April 3, 2019. The assessing officer completed assessment under Section 143(3) and made addition under Section 69 for unexplained investment in jewelry. The tribunal held that since seizure had taken place pursuant to search proceedings, assessment for assessment year 2019 to 20 ought to have been framed under Section 153A read with Section 153B and not under Section 143B and not under Section 143(3). Failure to issue jurisdictional notice under Section 153A rendered the assessment invalid. The Delhi Tribunal in the case of Shri Baba Bilakpuri Ji Charitable Trust versus Income Tax Officer Exemption held that where the assessee trust carried out various charitable activities and the object relating to running and maintaining a mandir and dharmshala did not override its other predominant objects. The trust could not be regarded as established wholly or substantially for religious purposes within the meaning of Explanation 3 to Section 80G. Accordingly, it was held entitled to approval under Section 80G. The Chandigarh Tribunal in the case of Pratibha Singh versus Asit held that where the assessee claimed that LIC investment of 50 rupees lakhs was funded by HUF out of agricultural income, but no books of account, no sale records of agricultural produce, or any documentary evidence demonstrating availability of such funds were produced. The amount was liable to be treated as unexplained investment under Section 69 in the hands of the assessee. Now we move to important updates under GST law. The Allahabad High Court held that where show cause notice was issued and demand was determined against a deceased person without issuing notice to the legal representative as required under the statute, such proceedings were not sustainable in law. The Madras High Court held that when a taxpayer does not respond to notice sent through a particular mode, the proper officer must explore alternative modes of service as prescribed under Section 169(1), preferably by registered post with acknowledgement due. An assessment order passed without effectively affording opportunity of hearing was liable to be set aside. In another decision, the Madras High Court held that where cancellation of registration had occurred due to non-filing of returns and the petitioner demonstrated that non-compliance was attributable to genuine reasons, such as physical illness and mental stress, the cancellation order was liable to be revoked subject to filing of pending returns and payment of tax dues along with applicable interest and late fee. Now we turn to updates under other laws. SEFMA, New Delhi. In the case of Kanav Gupta versus Deputy Director, Directorate of Enforcement, Delhi, held that where the appellant was involved in activities connected with proceeds of crime, constituting money laundering under Section 3 of the Prevention of Money Laundering Act, provisional attachment of his bank account under Section 5 was valid and within jurisdiction. In another matter, SafeMe, New Delhi, in the case of Vijeta Marines Private Limited versus Additional Director, Directorate of Enforcement, Chennai, held that where penalty had been imposed on a company for contravention of FEMA 1999 and on its director under Section 42 of FEMA, liability to pay penalty continued even though the company had been struck off from the Register of Companies. The penalty imposed was required to be paid by the company and the director concerned. These were the key updates under income tax, GST, and corporate laws for the week. Stay connected for further developments.